Martinez.
Morning, Judge.
Good morning.
How was your extended weekend?
Oh, it was great.
I was in your home state this weekend.
Oh, what were you doing there?
I was in Lake Charles. I'm assuming, I know you went to LSU, so I'm assuming you're from Louisiana. I was at Lake Charles, just R&R.
Oh, that's awesome. All right, you were on time for court today.
Yes, ma'am. And 30 minutes early.
Okay. All right, state. On Aiden Martinez, were you all able to tender an offer?
Yes, Judge.
And you have all the discovery?
No, Judge, that's the issue that we spoke about last time.
All right, what's the discovery issue?
This is a marijuana case, Judge, and the lab test identifies the substance as marijuana in the, is it health and safety code? It's not the health, it's the,
So agriculture.
there's the defense attorney would like to see the discovery packet, and ordinarily I would email, if it was the lab here, I would just email, I know, put an email over there, I've emailed. I need to track down who at DPS, the DPS lab can give me that discovery packet, Judge.
All right, Ms. Ferguson, recall this for 30 days. At that time, the discovery needs to be here. If not, you can subpoena whomever you need to subpoena from DPS.
Yes, ma'am.
June 20th. All right, we'll come back on June 20th.
Thank you,
Judge, you
Judge.
sign the reset form, you excuse.
Thank you, Judge.
Thank you. All right. Is Luis DeLeon here? Not here. Yeah. All right, are the parties ready on Jacob Borrego?
Yes, Your Honor.
So we have a motion to revoke, and is there gonna be a plea on two cases?
Actually, Judge, I think he's been continued on probation, I believe. And,
I was one judge last thing we were waiting on was the drug labs in this case.
so we're here on the newly indicted case.
All right, so the possession less than 1 gram case. I'm not sure where we had a hearing on the possession less than 1 gram.
Is that the probation case? Your Honor?
Yes.
We did something on it.
Yeah,
Yeah, let's go to lifetime.
yes.
On January 25th, it appears that NCR was withdrawn and maybe filed once the labs were present for the drug.
All right, so what I have on January 25th, withdrawn because of no labs. Alternate amend to lifetime recovery inpatient.
That's correct.
All right,
And obviously, Judge, he's been in straight custody since December.
okay. All right, so, and then we have the driving while intoxicated third. And there was supposed to be a PSI on that one. Oh, that's Christopher Acosta. Ah!
That's on a call.
All right, see, I'm just testing everybody.
No, I'm getting late, Judge, but. I was like, I missed that.
And Judge, I do have in my notes that he has been held without bond because it was another case out of the misdemeanor court.
Okay. All right, so you were without bond due to a misdemeanor. All right, court is calling. Everyone, don't talk behind the court reporter. Could we move Mr. Anthony Cantrell? I keep telling every attorneys these rules all the time and they forget. That's okay. All right, court is calling 2024 CR 3275, State of Texas versus Jacob Borrego. Could I have parties announced for the record for the state?
Daniel S. Barber, State of Texas.
Defense.
Patrick Hancock for the defendant.
And are you Mr. Borrego? Counsel, have you received all of the discovery? Did you review it with your client?
I did, Your Honor, and we have.
Court will find that the state is in compliance with discovery. Mr. Borrego? Did you sign the document entitled Application for Deferred Adjudication or Community Supervision?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count 1 and count 3 and the repeat offender enhancement allegation, and we're going on count 2.
Any objection?
No objection.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand in count 2, you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Again, make sure you keep your voice up so the court will.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Borrego, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, state is proceeding on count 2. There's a $1,000 fine to be probated. State recommends deferred adjudication, and there's a referral to felony drug court. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense,
Yes, Judge.
state,
Yes, Judge.
off the record for a moment. Probation, he's previously been referred to felony drug court.
Yes, Judge, and I believe he was a participant in felony drug court.
Okay.
And I was just looking into if they would take him back.
All right, thank you. We're back on the record. Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am, I did.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 10 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plea in count 2? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State officer exhibit 1 in all attachments.
Any objection?
No objection.
All right, you can continue to confirm. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are ready, Judge.
Anything you wish to say on behalf of your client?
Judge, I think this situation started back in December, folks knows will probably reflect. I think we asked the court to give him a bond on his MTR. And then he tested dirty, and I don't know if he tested dirty before you, I think maybe that was the condition to get the bond, so he tested dirty, so he sat in continuous custody. Obviously, he's clean now. We're hoping that he can go back to drug court if that's available, or I guess some kind of treatment for condition of the deferred adjudication that the court will think about. So I think he recognized the problem. Certainly the drugs that were tested and down on him make that problem real. And so we're asking for some kind of treatment.
All right, this is what the court is gonna do. Court is gonna sentence you to $1,000 fine. That will be probated. Parenting classes. You're not allowed to reside in any home with minors. There's to be no unsupervised contact with minors. I'll do a referral to felony drug court. If not accepted, then safety. And that's to be done in custody. There's to be regular reporting by Zoom or in person. UA hotline until further notice. Proof of employment within 45 days of release. There should be no employment as a home health care provider or with minors. Field visits, one time per month. Until further notice. There's going to be 120 sober meetings in 100 days upon, and 120 days upon release. You want to speak on the length of deferred adjudication?
Judge, obviously, Judge, anything less than 10, I think we'd ask the court to consider. However, at the same time, he knows that he needs the treatment, so let's leave that up to the court and its experience.
All right, I'll send you to 8 years deferred adjudication. Probation, is there anything else he needs?
No. So for the other case, we currently have listed as staying in custody until lifetime recovery picks them up.
All right, so we can add lifetime recovery. So we'll do felony drug court first. If not accepted to felony drug court. I think lifetime recovery is too short of a time. So if he's not accepted in a felony drug court, then it'll be safe P, and if not safe P, then lifetime.
Thank you, Judge. Do you want me to amend those conditions?
Yes. All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. You're gonna have to stop using drugs. If you don't stop using drugs, you could be one of those people on the side of the street, and your children will have to come and identify you. You understand?
Yes.
In this court, to be successful on probation, communication is key. If you feel as though probation is not addressing concerns you have, you can always come to the court. If you feel like you want to pick up and use, call your probation officer. If you feel like they're not addressing the issue and you feel like you're going to use, come to court. We're here except on weekends and holidays. Okay? All right, with regards to the case that's the possession less than a gram case, do you all want to terminate unset on this?
Oh, we could, then.
All right.
That'd be awesome, Judge.
So that is the.
Yes. So are you okay with that, counsel?
Yes, Judge, that's a great idea. Thank you.
All right, so we'll terminate on that because the other case is a higher level felony And he's on probation longer for that anyway.
That's right.
All right, is there anything else?
No, ma'am.
All right, thank you. All right, we're gonna go back on the record on Brandon Bowman. Court is calling 2023 CR 6541, State of Texas versus Brandon Bowman. That parties announced for the record for the state
Daniel Escobar from the state of Texas.
defense.
Wendy McCullen, the defense.
All right, and are you Mr. Bowman?
Yes, ma'am.
All right, Mr. Bowman, you previously entered a plea bargaining agreement with the state, and according to that previous plea bargaining agreement that was entered, it was for deferred adjudication. Now it's the court's understanding is that you no longer wish to receive the deferred adjudication. You're asking that you be assessed at 1 year in the state jail facility.
Yes, ma'am.
Why?
Because of the wait time for the program they're recommending. At first, when I entered the plea, it was just 3 years deferred, drug court, and some community service. I believe it was 120 hours. That I'm okay with. But if I'm gonna spend 8 months locked up anyways, you know what I mean? They have me in lockdown in here for something I shouldn't even be in lockdown. I just have a previous charge that.
Well, that's why you're in lockdown.
No, well, I mean, okay, I understand that, but it's like I'm being punished for something that it's not like I'm fighting, it's not like, anything like that. But I'm in 23 hours a day lockdown, and I'm not trying to do another 4 months like that, just waiting for the program, and then I gotta go to the program for another 4 months, that's already 8 months, I might as well just do my state jail, and then I don't even have to worry about probation. But, if you were willing to give me the probation with drug court and give me an opportunity to prove myself, I feel like putting me in a program, I haven't even messed up yet on probation, you already want to put me in a program. I mean, if I got an actual opportunity at deferred, and I got 3 little girls, 4, 2, and 1, and I'm missing them talking, missing them walking,
Okay, let me ask you this. Why are you missing them talking and walking?
because I messed up 2 years ago when I got this charge. I finally got picked up on the warrant, a year and a half later, and I got kids now, I got a family that I'm trying to take care of, trying to be at home with. If y'all guys didn't send me, I'm gonna spend 8 months of the program and still have to do 3 years probation, that's crazy to me.
Yeah. Well, here's the thing. I don't. I'm reading his PSI report. There are so many things that are going on with him. And the fact that he has young children, which he probably shouldn't be around, that's concerning for the court. So he has previous mental health issues. He has all of this drug issues that we're here for. And
What drug issues, man?
I mean, that's what we're here for now.
I understand that, but I'm saying with what drug issues, cause I said,
So you're just, so for this, what they were going to give you probation for, you're just selling, not using, is that what you're telling the court?
no, I'm not saying that.
Okay.
Who said that?
Well, you said what drug issues, as though you don't know the reason you're here.
Well,
You're here on a drug case.
I understand that, but I'm not out there on multiple drugs, all drugged out all the time. I have a job, I work.
All right. I'm not gonna follow the 1 year state jail facility. So he can either accept the probation with conditions that I'm gonna accept. That I'm going to accept, or either you all can come back with something other than 1 year in the state jail facility. So those are the choices. I'm not accepting
I guess it looks
the
like
new
I'm
plea
taking,
bargaining agreement of 1 year in the state jail facility.
I guess it looks like I'm taking the probation.
I'm sorry?
I believe I'm taking the probation then.
Oh, no, that's up, whatever y'all want to consider, but I'm not accepting 1 year in the state jail facility. If you all want to do something other than the 1 year in the state jail facility, the court will of course consider it.
For a less than a gram charge.
We can have a minute to discuss.
Sure.
CPR for 15 minutes.
You ready?
We're ready when you are, Your Honor.
Okay. All right, so we're back on the record. And 2023 CR 6541, Brandon Bauman. All right, so what have you all decided?
Your Honor, after much discussion with my client, he would like to try for the deferred adjudication and receive the treatments that the county is offering.
All right, anything else you wish to say on behalf of your client with regards to conditions?
No, Your Honor, I just do want to let you know that he has been in custody for 71 days. And he's really looking forward to getting in treatment, so he can go ahead and get that started.
And Ms. Abrams, on this case, was he considered for felony drug court? All right. All right, this is what the court is going to do. Court will sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person. The UA hotline until further notice. There's to be a referral to felony drug court. If he's not accepted, then they're asking for a evaluation for DDRF. But if he's not accepted into felony drug court, then next we'll consider lifetime recovery. And then if not accepted in that program, then we'll do the DDRF. And that's to take place while in custody. And he will not be released until he's accepted in one of those programs. If for any reason he's not accepted into either of those programs, then he's to come back to court. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the court will deem the community service hours satisfied. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Field visits. 1 time per month. Until further notice. And the defendant is not to reside in any household with minors until further notice. And there's to be 120 sober meetings in 120 days. Probation, is there anything else?
No, sir.
Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful on probation in this court, communication is key. If there's an issue, you need to let probation know. If you feel as though they're not addressing that issue, you can always come back to court And I'm sorry, one other thing, we'll have to do a gang evaluation. And there'll be a gang evaluation. I can tell you with that gang evaluation, you're probably not gonna be accepted into felony drug court.
Okay.
All righty.
When do these evaluations take place?
Felony drug court will probably be sometime next week. Lifetime recovery, probably in 2 weeks. DDRF, you'll have to ask probation.
Lifetime, what would make me not qualify for lifetime?
You have
And you're
gang
talking about-
affiliation.
And you're talking about inpatient?
Yes,
Okay,
you have gang affiliation. That's the
I'm not
problem.
even a gang member.
It's listed as Peckerwood on your,
I'm not active though.
all right, well, usually the way they label you as a gang member, once you're labeled as a gang member, you're a gang member. And according to the PSI report, it says current affiliation. It doesn't say past affiliation. All right, good luck to you.
My dog,
That's fun.
my baby, who might with us.
Yes, she's gonna be an empty nester, like all in one fell swoop.
All of us. Yeah. The house is very quiet and. Yeah, it's exciting. We like her, we like her.
Hello, Mr. Wortha.
I don't know what
How are you doing today?
you're doing.
All right, so here's the thing, when you're brought over, and mind you, I'm not taking anything as true, I'm just putting you on notice.
Yes, ma'am.
One, you can't be taking pins.
No, ma'am.
All right, number two, you can't be destroying stuff over there.
Yes, ma'am.
You understand?
Yes, ma'am.
So when you're brought over, you just need to sit in your seat. Don't touch any of the equipment, because that equipment, though outdated, is still expensive.
Yes, ma'am.
All right?
I understand.
So this is what's going to happen with your case. My understanding from your attorney is that you want to have a contested hearing. So what will end up happening is the witness that they're going to call, because both parties have told me there's only one allegation in the motion. And that allegation in the motion is that you did not participate in an evaluation.
Yes, ma'am.
So somebody's going to be brought over to testify. And they're either going to say you participated in an evaluation, or either they're going to say you didn't.
Yes, ma'am.
All right?
Yes, ma'am. The only thing was, I saw two different people for that. That's why I didn't know. The first one I saw, it was for the same evaluation.
All right. So here's the thing. What you believe the facts of your case to
Yes,
be,
yes, ma'am.
your attorney may not want you to discuss them
understand.
with me. So what I can tell you is, according to the allegations in the motion, they are saying, and I don't take any of it as true because they'll present witnesses. They're saying that you didn't participate in the mental health initiative evaluation in custody. That's it.
Yes, ma'am.
That's what they're saying you didn't do. So they're gonna bring in a witness, and that witness is either gonna say you participated in it or you didn't.
Yes, ma'am.
That's where we are. So your attorney tells me that you want somebody to be brought in to testify whether you participated it or not. All right, so that's what we'll do. And that person is gonna be by Zoom. It's gonna be somebody, both parties have told the court, it's gonna be somebody with Center for Healthcare Services. So that person who is alleged to have went to try to interview you is gonna come and testify by Zoom. And either they're gonna say, oh yeah, I recognize him. He participated in the interview, or either they're gonna say, yeah, I recognize him and he wouldn't participate. That's where we are. So we will come back. And we're gonna come back in June. And that is going to be, Ms. Ferguson, can we do this the week of June 17th? Is that enough time? State, defense, are you available the week of June 17th?
I'm double checking, Judge, because I have 2 murder trials next month. It looks like the 17th is good. My murder doesn't start till the next Monday.
All right, so Ms. Ferguson, we're having a hearing, contested hearing, should be relatively short. Mhm. All right, so we'll come back on June 17th. But before we do that, I'll go ahead and accept your plea. So that'll be one less thing we'll have to do on that date. All right,
Will that be at 9 on the 17th?
yes. All right, court is calling Just one moment. 2022 CR 6940, State of Texas versus Bernardo C. Huerta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Meredith Chacon for Mr. Huerta, Your Honor.
And are you Bernardo C. Huerta?
Yes,
Are you the same Bernardo C. Huerta who was placed on community supervision in 2022 CR 6940 for the offense of robbery on July 18, 2023 for a term of 8 years? Is that you?
yes,
State?
Violated condition number 39 on or about the 30th day of April 2024 in Bear County, Texas. The defendant, Bernardo C. Huerta, did then and there fail to participate in the mental health initiative evaluation in custody and comply with all rules, regulations, and instructions as directed by the court and or supervision officer in violation of condition number 39.
How do you plead to that? True or not true?
true.
All right, so if y'all want to go back and discuss things.
Okay,
All
thank
right,
you, Judge.
thank you. You're welcome.
You going back there?
Go back on the record and 2022 CR 6940. All right, Mr. Huerta, it's the court's understanding you've had time to speak to your attorney
Yes.
in regards to your plea of truth.
Yes, sir.
All right, do you still wish to plead true to violation of condition number 39 after speaking to counsel?
Yes, sir.
All right, did you understand by pleading true to violation of condition number 39, court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, Your Honor.
All right, the court will find violation of condition number 39 true. Is there a proposed agreement or no?
No, there is not, Your Honor.
All right, state, what are you requesting?
We're asking that you follow probation's recommendation, Judge, which is to alter and amend conditions for DDRF and to hold the probationer, hold Mr. Huerta in custody until the Center for Healthcare Services, the Tacoma evaluation, the TCOOMMI evaluation for DDRF is completed, Your Honor.
All right, defense, what are you requesting?
Judge, my client has been in since January awaiting the DDRF. The wait is very, very long for DDRF. There was, yes, he's pled true to not doing the eval. He did a part of an evaluation and thought he had completed the entire thing. But he would like the opportunity to do some sort of outpatient. Our understanding is the wait for DDRF is 6 or 7 months long potentially, which means he will be sitting in jail almost a year by the time that happens. And so is there anything, may I ask him if there's anything else?
Sure, but I will tell you, if you would have agreed to see them, you would have been done.
Yes.
And your 6 months would have been done.
Can I, whenever.
All right, do you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Bernardo, what's that?
All right, what
Yeah.
would you like to say?
Yes, sir. I do understand that, but it's still a 6 to 7 month wait. I have almost 2 years back time on this case already, just sitting in the jail.
Oh, do you just want to go to prison?
No, Your Honor, I don't.
All right, so here's the
But
thing.
I don't
Let's
ask
stop.
people-
No, stop. Let me explain something to you for a moment. Let's go off the record for a second. I don't know why people commit offenses. You plead to the offenses that you committed. You're placed on probation. You get a motion to revoke. The reason why you have the DDRF pending is because you were here for a motion to revoke a violation of condition number 4. Guess what? If you were not placed back here for a violation for your motion to revoke, you never would have been waiting for a mental health evaluation. What ends up happening is people are on probation. They're excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say? I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. It's sort of like when people say, I'm 1,000% sure that I'm clean. You know what that usually means? They're dirty. Anything anybody says that's beyond 100%, it's usually not true.
Yes.
So you came before me with that. You were placed on probation July. Then February 2024, you had a violation of condition number 4. And I remember you. You came before me. You were so happy to be continued and not be revoked. And now you come before me
I haven't.
and
gone nowhere
here's the
yet.
thing though.
I haven't got out of jail. I've
Here's
been
the-
in
here's
jail
the
this whole
thing.
time.
Here's the thing, but the reason why you're in jail is because of your actions.
Yes, Your Honor, and I understand
And
that.
people will come before me, and let me just tell you what happens. Some people will come before me and they'll say, I don't belong to a gang, I don't do drugs. Or I pay child support. And I always ask people when they would say, I pay child support, what, you want a cookie? That's something you're supposed to do. Like, you're not supposed to be before me on motions to revoke because you're supposed to be doing what you're supposed to be doing. And whenever I give people conditions, or whenever probation recommends conditions for them, they want to write their own program. If you could write your own program, guess what? I wouldn't have a job, defense attorneys wouldn't have a job, the state wouldn't have a job. It would be great. But you can't appear before the court and then decide that you're writing your own program and you deciding that you're not going to follow through and speak to the person. If you would have spoke to that person in April, your 6 months would have been done. You would have been either in DDRF or not. They would have transferred you. But you know what? You've been pushed back. You know why you've been pushed back? Because you did not want to do the other interview because you're like, I'm done. And I always tell people when you're on paper, and that's what this is a contract, you're on paper. Even if somebody tells you, we're coming here for an interview, and even if you've thought you've already done the interview, doesn't hurt you to go ahead and do the interview, then you can come to court and say, they came to me for an interview for a third time and I had already done the interview. Then we can discuss that. But when you don't follow through on what you're supposed to do, guess what ends up happening? Everything falls and you get placed at the end of the line because guess what? There's somebody there who's on probation who had to be interviewed for mental health and DDRF. And guess what? They took your spot. That's where we are.
That's the only thing. I'm just seeing a lot of people coming back, a lot of time waiting for it.
Yeah. I mean, I make rulings and there's a reason why these rulings are made. Right? And then you're also on, I believe you're on gang supervision as well.
I'm not sure.
Is he on gang supervision?
Sorry about that.
Well, were you a previous gang member?
I used to be, yes.
All right, so he was on gang supervision. So I have somebody standing before me who is on gang supervision. You know, you're given probation, the state recommended community supervision. And then you're over here pulling stuff off or trying to pull stuff off. That's why you have the DDRF. Now, if you don't want to wait for DDRF, I can revoke you. You guys can talk over what time you want and I'll do what I will with regards to time. And guess what? You'll go to prison, you'll do your time, you'll get out. Either you're going to act right and follow the rules and conditions of society, which don't pick up any new offenses, take care of your children, stay on the straight and narrow. If you don't, you'll probably end up being a habitual and your minimum when you come back will be probably 25, or maybe it'll be as a repeater in which case your minimum will be 15, depending on the charges. So if you want to discuss with the state and your attorney about doing your time, then you can do your time. And legally, I have to give you credit for any time that you've been in custody towards your time. So if you want to talk to your attorney about that and talk to the state about that, I'm not saying if they want to, if they agree to revocation and they want to give you a specific amount of time, I'm not saying I'm following that, but I'll consider it. All right. So if you want to talk to your attorney about that, you can. So I'll let you all talk about that and I'll do this plea. All right. Are the parties ready on Israel Fuentes Gonzalez?
Yes, Your Honor.
Oh, just 1 second. Are you ready?
Yes. But I do have to put something on the record. Judge, just to confirm, Navarro is not for PSI or TAP?
No.
Okay, thank you.
All right. So you need to put something on the record?
Just at the beginning, I actually did ask you.
Okay. All right. We'll do that and then we'll take yours up. All right. We're back on the record in 2022 CR 6940, State of Texas versus Bernardo Huerta. And Mr. Huerta, you're still under oath. All right. Defense.
Mr. Huerta, we talked over the break about whether or not you would agree to go to DDRF, and you've indicated that you do not want to do that, correct?
No, I'm trying to get an outpatient vote on the thing.
Okay, and knowing that that's not an
Oh,
option.
just 1 second. I'm sorry. I don't know if the court reporter heard his answer.
Can you repeat that?
I was trying to get an outpatient program, or anything, but no,
The last part.
but if it's not possible.
All right, so you're trolling off. So my understanding, and correct me if I'm wrong, your answer to the defense counsel question is you're trying to get into outpatient treatment. Is
Yes,
that
ma'am.
correct?
Yes, ma'am.
Oh, it's fine. He's just mumbling. And if you're not able to get into outpatient treatment, then what was the next thing you said?
Not figure out what happens.
All right.
Mr. Worth, I explained to you the only options in front of you are DDRF, if you agree to it, or that we have a sentencing and the judge will determine how much time you receive. Do you understand that?
Yes,
And since outpatient is not an option, would you like to avail yourself of the opportunity to do DDRF? Or do you want to be sentenced today?
I guess we'll sentence.
Okay, and I advise you to go with DDRF, correct?
All right.
That's all I had to put on the record. Judge.
Thank you. All right, so he's pled true to violation of condition number 39. Is there a proposed agreement?
There's not, Your Honor. I would ask the court, I know that the defendant has stated that he would like to be sentenced. I don't think you should do that. I think you should say, hey, you're going to the inpatient. That's, I think that's a better option for him. If, I know he said he wants to be sentenced, but, and I can speak to that if the court would like to.
Sure. I mean, here's the question, Mr. Huerta. You don't get to decide whether you're in inpatient treatment or outpatient treatment. Now, they want to interview you for DDRF. Either you're going to do that or you're not going to do it. So, do you want to be interviewed for DDRF? Yes or no?
Yeah, I guess.
No, it's not, I guess. It's either yes or no.
Yes.
You can't write your own program. Here are your options. Your options are you can be interviewed for DDRF. And if they deem that you're acceptable to the program, that's where you're going to be. Or if you don't want to do that and you tell the court you don't want to do that, then I will revoke you. Those are your two options. Now, if the court were to revoke you, then the most I could sentence you to is 8 years. I'm sure your attorney will ask for something probably less than 8.
20 years just to this deferred.
No, he's not on deferred. He's on regular.
Is okay? Oh, okay.
Yes. So,
I was on deferred also. Okay.
no, he's on regular. So the most I can sentence him to is 8 years. So, and he legally, I have to give you credit for any time served that you've been in custody. So those are your options. Do y'all need to discuss this again or no?
Do you want to do DDRF or do you want to be sentenced? That's not an option. The judge has told you and I've told you there's two options. Sentenced, we don't know how much time, up to 8 years. Okay. To be
All right, so you want to be sentenced?
Yes,
All right. You've pled true to violation of condition number 39. Court is finding violation of condition number 39 true. State, what are you asking for?
We're asking for the 8 years, Your Honor. The defendant has been to the prison in 2010 for an ag assault with a deadly weapon. I know you've seen the SIPs in this, and I know it's a robbery, Judge, but it came in as an ag robbery. This was, the defendant was stealing from an O'Reilly's. When the employee tried to stop him, he pulled a knife on the plain witness in this case, Judge. So this is an inherently scary crime, Your Honor, and so that's why we're asking for the 8 years, Your Honor.
All right, defense?
The client would ask that you give him the minimum of 2 years and credit for time served.
The court is going to grant the motion. The court will sentence you to 8 years in the prison. The court will give you credit for any time served. There's to be, just one moment. There's to be no contact with Abel, ABEL Ramos, and O'Reilly's located at 955 South General McMullen, San Antonio, Texas 78237. And there is to be a $500 fine time and money were run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yeah.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegation in the motion, not the fact that you're on community supervision. Do you understand?
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay?